Hi everyone, I'm here with Andrea Ranson from Onyx Legal. She's one of our team members based in Mackay, so she works remotely, otherwise she would be here with us this evening. So Andrea has a lot of background and experience in working with leases. We work with both landlords and tenants, but the conversation we're going to have today is more focused on tenants. So Andrea, what are some of the most important considerations that people should keep in mind before going into a lease?
Thanks, Jeanette. Firstly, I would say know the transaction that you're entering into. It's really important to know whether your documentation matches your intentions. So if this is a commercial lease, then typically you will be using a standard REIQ template contract, or whether you're entering into a retail shop lease. And the reason that this is important, it's not only the documentation that needs to match your intention, but if it is a retail shop lease, then the tenant is afforded greater protection by law. So that's fundamental. Get this right, get it right from the start. Don't be tempted by somebody saying to you, look, it's quicker, this will save us money, we'll just use a standard REIQ form. In fact, honestly, Jeanette, it's false economy. Because they miss out on those really important protections.
And it can make the world of difference, particularly 3, 4, 5 years down the track.
For sure.
Yeah.
For sure. And can I say, as a mediator in this space as well, so as you know, I work with retail and commercial shop leases from the outset, drafting and negotiating, but also when they're in dispute as a mediator. So I sit and I listen to both sides of the fence, arguing parts of a lease that was done 5 or 7 years ago. And, I see things like someone trying to argue that QCAT, which is a really fast, what's meant to be an efficient and fast access to justice, low cost. And QCAT has a specialisation in retail shop leases. So what I see is landlords perhaps trying to frustrate that process by saying, well, there's no jurisdiction here because these documents are for a commercial lease, not a retail shop lease. So that in itself can cause stress, delay, expense for everyone. So to circle back, know the transaction you're entering into.
Absolutely. Very sensible place to start. So once you know what transaction you're entering into, what comes next?
Well, you're probably really excited by that stage. You've been doing some negotiations, you've found the premises, it seems ideal. What I'm going to say to you is slow down, please slow down. You're not on anyone else's time frame, but your own and your business. And as a business owner, that is incredibly important to understand and to stick to that, especially when you're getting pressured. You'll be told, there's no flexibility on the other side. This must be done by a certain date. Slow down, slow the process down, and take advantage of the fact that you're not in a rush to do this, or you shouldn't be in a rush to do it. But this is your really fabulous opportunity to design the best lease for your business. And you don't really get that opportunity at any other stage. So slowing down, making sure the documents are right is really important. And I'd add to that, Jeanette, that there's 2 stages to this leasing process, okay? 3 stages: negotiation, lease offer, and lease, okay? And in each of those, there's some crossover. But with your lease offer, a lot of people, particularly landlords, they'll come to their solicitor once the lease offer is signed. Tenants tend to think they should do the same. It's not, in fact, the case for either party. You can come at any time to your lawyer to ask about the lease offer. But in fact, can I just say, part of that slowing down that I've referred to for a tenant is really important, because if you bring that lease offer to somebody to look at for you, and even your accountant as well, for the accounting and financial taxation advice, which is really important because lawyers aren't accountants.
Not at all.
No. So again, that opportunity to design a really perfect fit for your business happens at that lease offer stage.
And it's
Yep.
When you think about the length of time that you're entering into this lease for, the more thought and time you can take at the beginning to really consider where your business is going to be in a few years' time. Also, what's in the market. You know, the first property that you find may not be, in fact, the best one for you. If you look at these things before you sign a lease offer, you're at least not committing yourself to potentially lose a deposit amount or bind yourself to some terms that in 3 years' time are going to look not nearly as good as you thought they were when you signed the lease.
Oh, absolutely. And one thing that I say to people when they're entering into a transaction is do your due diligence. And there's a lot of steps that we can go into that we don't have time tonight. But what does that mean, the due diligence, okay? It's things like comparing like premises in other suburbs or other centres, finding out what incentives landlords are offering, finding out whether there have been any security issues or flooding at that premises. That's all part of due diligence. So start from the start, do it all right, get as much knowledge and information. And in fact, your negotiation matures as you do this. That's what I tend to observe. And then people feel more confident to push back when they see an unfavourable term, say in a lease offer. They're happy to go, well, okay, well, I'm going to push back on that and ask for something better.
Okay, coming back to lease offers and deposits, can you share a little bit more about that?
Sure. I think one thing that's you've really got to look out for is understanding the implication of the lease offer. So the lease offer will often say, and I see this 9 times out of 10, excuse me, I will see that the landlord is only bound when the final lease is signed by both parties. So that doesn't seem unusual, but there are problems with that. The tenant on the other side of things is bound when the lease offer is signed. And the implication of all of that is that you've paid a deposit, generally 1 month's deposit, but it can be more. And that can be a sizable amount of money, and that's put at risk. So if you're bound, when you think about this logically, if you're bound from the lease offer and the negotiations go astray along the way, the landlord can get out without any financial implication. You can't, because your deposit will most likely go to the landlord's solicitors. So that's a really important aspect to understand. So getting that wording right at the start in the lease offer is really simple. We simply just amend the lease offer, send it back with the wording that both parties are going to bear their own costs.
Yep, great idea. Now, you also mentioned before about incentives. Can you tell us a little bit more about incentives and maybe some things that are currently happening with our clients?
Sure. Landlord incentives. Firstly, if you're not getting any, why not? Okay. Definitely be asking the question. So landlord incentives, Jeanette, are generally a contribution to the fit out cost. And remember with that, it is a contribution towards it. It's not an entitlement to a lump sum in your pocket. That's not how it works. Yeah. So paying actually what the cost of your fit out is. Rent-free period and a period of rent abatement. Generally what that means is, say, half rent for a period of time. Now, rent incentives, if you are getting them, are wonderful, but there's a couple of things to look out for that I'd like everyone to really think about and understand. Firstly, in almost every lease I see, draft lease, there are what I call incentive repayment triggers, and those effectively mean that if a certain series of events occur, such as default in lease, which could be late payment of your rent, generally it'll be a little bit more significant than just once, although that is significant. Assignment of lease, selling your business, changing your business name, you are at risk of repaying these incentives. Now, if we're talking about an incentive that's $80,000, what I say to our clients all the time, Jeanette, is what happens if you decide that you need to get out? Are you going to have $80,000 to pay back? And the answer is generally no. So in a lease, it might be called a clawback, it might be called a repayment trigger, or it won't even have a name. So it's hard to find. And I can tell you in one of our cases, Jeanette, that I found in 6 different spots, 6 to 8 different spots in the draft lease, randomly inserted clauses. And I say random, I think they were rather with intent, but they're inserted in different spots where you wouldn't expect to see it perhaps. And so a trained eye can see it.
Yeah.
The same effect, the same net effect without giving it a label. So it's really important. So make sure, firstly, know what you're getting into. Make sure you understand what the triggers are to repayment and do they suit you. So generally speaking, our advice to our clients is don't agree to any repayments. Push back
that's
on
right.
that. You know,
Yep.
don't. The other important part is you need to know the taxation implications of your incentives. Yeah. And I can say that a really important question around that is, should you own the fit out or not? So we have a particular client who really always wants to own the fit out. Yeah. And that's absolutely wonderful. And is aware of any taxation implications, asks the right questions, is well educated on it. Others don't mind, but there are some clear advantages. So either way, but you do need to speak to an accountant to understand tax. And Definitely. The other part of it, just to understand, is, again, we're designing something for you at the start of a lease. So work out with your contractor when it's best to receive payment, marry that up so your cash flow is freed up. Okay, so generally speaking, the landlord will pay the incentive, if asked, in 2 lots, 50%, for instance, upon commencement of the fit out, and 50% on commencement of trade. That's a nice clause. But what we see is that, and there will be a whole series of steps that tag onto that. Okay, yeah. So you have to give invoices, you have to give, evidence of what you've done, insurance and the like. But what we see is just a lump sum. We'll give this to you 30 or 60 days after you start trading. So that means if your fit out is $80,000, you've had to fund that. And that comes at a cost to you. So be smart, talk to someone about how to break that down and how to make those contributions work for you.
Absolutely. Yeah, very sensible suggestion. Okay, Andrea, so you've spoken about what happens at the beginning of a lease, and there's a whole lot in the middle that we could talk about, but I don't think we have that much time. So let's have a look at what can people do, or how can they design what's going to happen at the end of the lease?
Okay, well, again, that's really important, and you've got your best opportunity at the start to think about the end. So it's really important to understand that when a lease expires, firstly, unless you've got options to renew, then you don't have a right to stay on. If you do stay on, you're in a period called holding over. That's okay, there's no problem being in a holding over as long as you understand it's a month-to-month tenancy, meaning the landlord only has to give you 1 month notice and you need to move out. And that's not really that easy for a whole business to leave. But the most important part about designing and understanding and really being clear at the start what your end is going to be is, what are your obligations to make good when you hand back the premises? So make good is a very common term that we use, but there are some other parts of that. And those other parts are, I might just give a case study because that's a really good way to do things. A lease that I'm looking at, the client is negotiating an as is where is. So they're walking in and the fit out's there and they're entering on that basis. At the end of the lease in this draft document, it has a bare shell requirement. Now, bare shell means that you have to defit. So the previous tenant is handing over to us, if you like, as is where is, they're not paying a defit. The landlord's getting a speedy and swift transition from one to the other in tenants and rent coming in. But at the end, the landlord's getting landlord. That's it. It's really important. And at the end, the landlord's getting a bare shell. And if it's not going to be the same type of business, then the landlord prefers a bare shell, okay, to start with. That's a big no for us in this scenario. So we've said to the client, no, you take it as is where is, you leave it as is where is, subject to making good any damage along the way that you might have caused. You clearly have to do that. That's your obligation. But what I wanted to also point out, Jeanette, is fit outs are incredibly expensive, and people, I find, if it's their first time, they don't really conceive of that. And one client we've got, I had said to them, really please do your due diligence. You need a contractor now. And they were estimating what the costs might be, and not even in the ballpark. I know that. So it came back at, it might cost us about 5,000. It's actually 70,000 plus, which doesn't surprise you or I.
No, not at all.
And in a case, actually someone I know, a colleague who has a series of pharmacies, their defit is $250,000. So
Extraordinary,
my point
isn't it?
is, it's extraordinary. The defit can be the same or more than the fit out. Makes little sense to us, but that's how it is. So remember, design it how you need it at the end. And if you're going to need to budget for $80,000 at the end, make sure that your accountant has sat down with you and worked out how that's going to happen. Because if that happens in 3 years or 5 years, you're going to have earned enough money to have that money aside. So they're all important considerations.
Yeah. And I mean, part of that as well, it interacts, it's not a standalone thing. So it interacts with who owns what in regard to the tenancy. So what part of the fit out, if any, does the landlord own? And if the landlord has contributed part of an incentive to the fit out, do they then try and retain the fit out and all of that sort of thing? From that perspective, if the landlord owns the fit out, then your defit will be different to a bare shell, because you're not obliged to defit what is already the landlord's fit out. So,
well, here's the thing.
Yeah, depending on what's
here's
written
the thing
in the
about
lease.
it. There's always a but.
Yeah.
The wording. If my greatest tip to everyone tonight is please read every word of these documents. Now, you will have, as any other human has, fatigue by page 3 of 47. So that's why you need to get someone to read it for you as well. It doesn't take away or mitigate your obligation to read, but that trained eye is really important. I have seen leases where the fit out is stated as owned by the landlord, but it's almost like a discretionary ownership. So they can own it if they want to at the end for $1, but they don't need to. Or it'll state they own it, but you still must do bare shell. So again, every part of the lease document is so critical that it's read. And, you know, as humans, when we look at the same document over and over, you tend to want to say, oh, well, okay, that's about this. So, and you don't look at the detail as much as you should, where you actually have to with leases.
Yeah, absolutely. All right, now I know there's a lot more that we could talk about, and there's a lot of sort of horror stories or war stories that we could tell. But what are your key takeaways for people for this evening?
Sure. Get legal advice, get accounting and taxation advice. I think that's critical. Plan for success at the start. That's a phrase you and I use a lot in our daily practice as lawyers. So do all of your due diligence. And if you're not sure what that means, ask. We're here to help you. We've got commercial experience. We've both got experience in business as well. And any lawyer, a commercial lawyer should be able to help you with that as well. So push back on terms that are not favourable to you. You don't have to agree to them. We have clients who simply refuse to give a personal guarantee, for instance.
Yeah.
And most people would say that's impossible. It's not commercially viable to push back on that. In fact, that client does it with success every time.
Yeah.
So do that. Know your transaction, slow down. Incentives have red flags with them. They're a good thing, Don't shy away from it, negotiate it with vigour. However, know the red flags and know what you need out of the lease documents. And fundamentally, Jeanette, it's about knowing that your lease document is the most important document for the transaction. So it's your go-to guide for whenever there's any sort of issue that arises. Yeah. So you need to design it. You need to know what's in it. You need to know your rights and responsibilities. So respect that document, treat it with respect, and invest in the process from the start. Absolutely. Rather than from the dispute perspective, because I see a lot of leases in my mediation role, and I say very frequently, hindsight's a good thing, isn't it? If you had your time again, that clause probably wouldn't be there. So don't take it out now.
Yeah, absolutely. All right, well, that's fantastic. Thank you so much. And if anybody here would like to have a chat with Andrea, we have a make an appointment button on our website, onyx.legal. On the front page, right at the top on the left-hand side, there's a make an appointment button, and that'll take you to a booking page where you can book some time with Andrea. There is a cost involved in that, but, consider what's been said today. Being able to answer your questions early in the piece and know that you've got some clear direction and peace of mind going forward is certainly worth its weight in gold. So thanks very much for your time today, Andrea, and
thanks,
I'll
Jeanette.
see you again soon.
Thank you.